Good morning, good afternoon, everyone, and welcome. Thank you for joining us today for this session of our monthly session of our legal updates for Canadian employers. I'm Colleen Hoey, and I'm counsel in the Dentons Ottawa office in the Employment and Labour Group. And I'm joined today by several colleagues who will be sharing insights on key issues we've seen emerging across our client base. And our goal is to help you anticipate and prepare for these challenges before they land on your desk. Our speakers today include Jonathan Moore, a partner. Jonathan advises employers on complex business immigration matters, including work permits, labor market impact assessments, and compliance issues affecting workplace mobility. Next, we'll be hearing from Barbara Wallenick-Hatch. Barbara advises clients on pension benefits, executive compensation matters, including governance and regulatory compliance, and plan-related issues arising in corporate transactions. Next, we'll hear from Claire Brown. Claire is a senior associate who advises employers on a broad range of employment and labor issues, including workplace litigation, wrongful dismissal claims, human rights matters, and occupational health and safety issues. And finally, but not least, we will also be joined by Anil Nair. Anil supports employers on employment and labor matters, including workplace disputes, again, compliance issues, and litigation supports across a range of day-to-day and complex matters. Thank you, Jonathan.
Thanks, Colleen, and hello all. Yes, I'm Jonathan Moore, and I'm based in Toronto, and I will be tackling the employer risk and compliance aspect of employment from an immigration perspective in Canada. So, just to start off, I mean, there are plenty of reasons why compliance with Canadian immigration law is important, but if we were to choose one, it would be this provision that you see under the Immigration and Refugee Protection Act. So Section 124 makes it an offense to employ a foreign national who does not have the necessary authorization. It's also worth mentioning that the Act finds that anyone who doesn't try to determine whether the foreign national has this authorization to work will be treated as if the employer knew. I'll say a couple of things. You know, the way this is framed certainly sounds severe, and it's likely intended to. But I think it's important to consider what this means from another angle. And it provides a ready-made defense for those who employ a foreign national who isn't authorized, so long as the employer can show that they exercised due diligence. So I think that's sort of our jumping off point. We can move to the next slide. So that's where we are. What can an employer do to show that they did exercise this due diligence and protect the organization? The answer is relatively simple. It's about asking the right questions at the right time. And I'd suggest that the focus would be here. We split this up into looking at what questions do you ask during hiring and then post-hiring. So when looking to hire a foreign national, the question is simple. Is this foreign national candidate authorized to work for our organization in the position that we've offered them? At post-hiring, we look at, can we make any changes to this employee's position or their terms of employment during their work authorization? And also, when will this employee's work authorization end? Yeah, I mean, these are, I think, the key questions that we look at. So let's move on to the next slide. So at the time, let's start with the time of hiring. And the issue is, you know, can this person work for us? And are they authorized to work in the position that we've offered them? So to figure this out, we look at evidence of their immigration status and the authorization that this status gives to them. And it's exactly this type of due diligence that protects an organization under that Section 124 of the Act that we looked at. So when thinking about immigration status, we can divide it up fairly simply. We look at temporary foreign workers, including those who have open work permits and those who have closed work permits. And separately, we can also look at international students, including those who are just authorized to work off campus during the school year, and then those who are able to work under what we'll call a co-op work permit. Next slide. So we'll begin with what I see as sort of the simplest form of work authorization, and that's an open work permit. So I think many of you may already be familiar with what this is, but it's simply a work permit that does not specify any employer. And so it authorizes employment with any employer. It's the simplest form of work authorization, and it requires the least amount of diligence to examine. So we can boil this down to just a few simple steps. Ask for and review the work permit to confirm that it's open. And to do that, we look to the employer field on the work permit and confirm that it says any employer or open, or it's simply blank. It's also worth quickly looking at the occupation field just to see that nothing is specified there. Occupation-specific work permits do exist, but they're relatively rare. Moving on to the next slide. Closed work permits only authorize work with a particular employer and always in a specified occupation. It's also worth mentioning that even where your organization did facilitate this work permit, and so your organization is listed as the employer, it's still important to review it before the foreign worker's first day. Immigration officers make mistakes too, and in rare cases, some corrective action will be necessary, and figuring this out in advance can also protect the organization. There are a few exceptions that allow a foreign national to work for an employer other than the one listed on their work permit. Just very briefly, if a new employer supports a work permit application, then the candidate is allowed to request interim authorization to start work in the new position while the application is in process. On another note, there are corporate reorganizations and a lot of nuances there, but a good example is where a new organization acquires the company that's listed on the work permit. And if certain requirements are met, the acquired company's foreign workers are authorized to work for the new organization. Moving on to the next slide. Now we can move on from workers to international students at the time of hiring. So briefly, many, not all, but many international students are authorized to work off campus for any employer as long as it's no more than 24 hours per week during the school year, so long as they meet these requirements. So they hold a study permit, they're enrolled as a full-time student, and they're enrolled in a qualifying academic program, at least 6 months in duration and at least to a degree, diploma, or certificate. So some important steps to take here are just ask for the study permit and take a look at it. In many cases, there will be a notation at the bottom that even says authorized to engage in employment off campus. But also there are these other requirements that are probably a bit harder to confirm, and you won't be able to figure that out just by looking at the study permit. So what I would suggest is simply asking the international student to confirm this, and best to do so in writing, maybe even just by email, and keep a record of that. And that can serve as very good evidence of the employer's due diligence in trying to determine whether they are authorized to work off campus. So just relatively simple steps to take. Separately, many international students are required to complete a co-op or practicum component of their program of study, and they're issued a co-op work permit to do so. What's important to understand when a student shows an employer a co-op work permit is that it's really intended for a very specific type of position. So it's for employment that forms an essential part of their program of study. So not just, any position or anything like that. Um, and so it takes a little bit more here to figure out if this person can work for you. So number one, you always want to ask for and review both their study permit and their co-op work permit. But the key piece here is to find a way to confirm that their university or college is aware of and has approved the co-op employment with your organization. And there are a number of ways to do that. They can provide an email from their school or a formal letter. And some schools even provide a sort of online portal for co-op students, which will show all of the relevant info. And if you see your organization name there and that it's been approved, you can be fairly certain that the school is aware of and has approved the co-op term with you. Moving on to the next slide. So now we're switching gears and we're talking about compliance issues after hiring. And the questions that I would ask at this juncture would be, can we make changes to the foreign employee's position or their terms of employment, while they work for us? Similarly, I would also always ask, when will their work authorization end? So again, we'll look at these questions um, in accordance with what immigration status they hold. And this time we'll start off with international students, and then we'll move on to temporary foreign workers. Next slide, please. So for international students, so those who met the requirements that we briefly covered before, number one, they're not tied to specific employers, and they're not tied to specific positions. So these types of employees can absolutely change positions or have their terms of employment altered during the period they work for you. That's not an issue. The largest thing to keep in mind with international students and off-campus work is, when does that work authorization end? And that happens when one of three things occur, whichever happens first. Number one, when their study permit expires, or they cease to meet eligibility requirements for off-campus employment. Let's say they change status to a part-time student, or they receive any written notification from their school saying, you're done your program. Um, and steps that can be taken, keep a copy of the study permit on file, diarize that expiry date, and then just inform the student employee in writing that they have to tell you whether any of these things happened. And if they don't, at least you have a record that you've asked for them to do so. Next slide. For co-op students, I think the most important piece is, you can't change too much about their employment. The co-op was meant for a very specific type of experience that they're supposed to gain, and so making changes without the school's knowledge is unlikely to be a good idea. The second piece is, co-op terms are limited. They're usually a school term, 3-4 months. And that date can be easily confirmed with the student or their school. So keeping an eye on that is helpful. If the term does come to an end, it may be possible for them to continue working under the off-campus work provisions, but to figure that out, you'd have to review their eligibility. Moving on. Switching gears to foreign workers. Again, open work permits, very simple. Take a look at the expiry date. Changes to their role or compensation, absolutely okay. And when it comes to their eligibility to extend or renew, that is less simple. And you'd have to look at the category of work permit to determine that. And so here are a couple of examples. Post-grad work permits can only be issued once, regardless of how many educational programs the student completes. Spousal open work permits, on the other hand, can likely be renewed many, many times, but taking a look at their specific circumstances, always a good idea. And finally, closed work permits, the most restrictive form of work authorization. So, occupation generally cannot be changed. So it's a good idea to be careful with promotions or changes to duties or any changes to terms of employment. It's worth mentioning that when employers support a closed work permit application, they're committing at the outset to certain defined terms of employment. And so making changes to these terms need to be examined in advance just to ensure that you're not going to render the organization, uncompliant with commitments that were made at the time the application was submitted. Also, employers who support these closed work permits can be subject to random compliance inspections. And it would be at this time that sort of uncompliant changes that were made will come out, and there may be consequences for that. Next slide. Perhaps the simplest part of the closed work permit is look at the expiry date. If the employee wants to renew their closed work permit, that can't happen without your organization's participation. And it's worth noting that if you do choose to support their renewal application, the employee can be granted what's called maintained, or it used to be called implied status, to continue working while the renewal application is in process. So you would ask them to provide you with proof that the application was filed and just check that it was filed before their current work permit expired. And a few final notes on maintained status. It only allows the worker to engage in employment under the old terms of their expired work permit. So you can't make any changes during this interim period unless the new work permit is approved. And the new work permit also has to authorize those changes. And there's an option where the foreign worker can actually request sort of interim authorization to change positions during that period, but that is a sort of a separate process, and IRCC needs to specifically approve that. And now we move on to our next speaker.
Hi everyone, thanks John. My name is Anil Naya and I'm an associate in the Toronto office. I'm predominantly a health and safety lawyer, so today I'll be talking about the management of workplace incidents from a health and safety perspective. Workplace incidents are not something you want to happen at any time in any organization. Unfortunately, for lack of a better word, accidents do happen, and how your organization responds is crucial. Ensuring compliance with the law and eventual ease of dealing with the litigation process is important. However, it's best to start off with how you can be best prepared for an incident before it even happens. While I could go on for hours on the best way to mitigate this, I'll try and condense my thoughts to two overall main points. Firstly, training. The Occupational Health and Safety Act broadly requires most training to be given yearly. Make sure that this is done, and most importantly, make sure that it's recorded. Secondly, policies. The Occupational Health and Safety Act broadly requires most policies to be updated yearly, and when you do update these policies, the best safety programs I have seen will simply have a cover page stating when the policy was updated and by who. Now, let's transport ourselves back to when the incident first happens. To paint the scene, let's assume there's a critical injury on the work site. Critical injuries are a tricky problem to navigate, but generally speaking, if there's a loss of consciousness, obvious broken bones, but not to toes or fingers, amputation, substantial blood loss, or significant burns will meet the definition under the Act. Essentially, the definition encompasses anything that places life in jeopardy. Under the Occupational Health and Safety Act, when a critical injury or even death occurs, it must be reported to the Ministry of Labour, Immigration, Training and Skills Development. I'll just refer to them as the Ministry of Labour from now on, through what is known as a Section 51 report. The Ministry of Labour must be notified immediately, and the Section 51 report must be completed and sent in within 48 hours. This report encompasses the overall information of what had happened, who are the relevant parties, and other associated key information. A common occurrence which you can be charged for is failing to inform the Ministry of Labour in a quick enough time frame. Why does this happen? Confusion within the health and safety team is the most frequent culprit. I had a case a few years ago where the health and safety team did not report the injury because the worker walked it off. His legs were crushed by a water bin in a deep underground mine. He also, wrongly, was working alone and it was spotted on CCTV. The injured worker was seen on camera getting hit, then slowly and gingerly walking away. He had a limp for sure, but he did not request for medical attention, nor did he request the help from a colleague. This happened on a Friday, and over the weekend, no one checked in on him because no one knew he was hurt. And come Monday, he walks into the ER, says he has a broken ankle, and it was from his job. This act automatically notified the Ministry of Labour, the hospital had to tell them, and they sent out an inspector to the worksite to conduct an investigation. It was later discovered that he knew he shouldn't have been working alone, and he was fearful that reporting his injury would make people know he was working alone and he was worried his job was at risk. The company was charged, amongst other things, with failing to properly notify the Ministry of Labour. Eventually, the other charges were withdrawn for other reasons, but the Crown refused to withdraw this charge, simply because factually, the company did not inform the Ministry of Labour in the correct time frame, didn't fill out the Section 51 report. So why did this happen, and how can you, as a leader in your organization, prevent it from happening? First of all, it's building a proper safety culture, safety-oriented culture, which would lead to the proper reporting procedures being met. Ensuring that all workers know that if they have been hit or something has fallen on them, no matter how minor they feel it is, they must report it to the internal health and safety team. This internal health and safety team should then decide in consultation with legal counsel if the injury meets the definition of a workplace critical injury and must be reported or not. Creating a positive culture, ensuring that workers or employees feel safe and secure enough to report an injury is of utmost importance. Safety days or safety weeks in which your organization may run should include information like this to help foster the environment which encourages self-reporting without punishment. Ensuring that supervisors and managers on the ground disseminate information like this is also crucial. It's fine to have written policies and procedures, but the implementation on the ground is what is crucial. I run mock investigations with clients where I would come into a workplace and act as a Ministry of Labour inspector on a mock scenario. And it is shocking to discover that many clients have a policy which the senior leadership are proud of and believe they are implementing correctly. But when I interview the lower rung employees or workers as a neutral third party, they are unaware of the policy. Instead, they rely on what they have been told is the best practice from their managers or their foreperson, who may have learned this years ago and are trying to impart it into a new employee. Luckily, in these scenarios, they're only theoretical and no one is actually hurt. But it's important for organizations to be attuned to what is their managers and supervisors imparting on new employees. Whatever is in the training manuals and has been improved by senior leadership is what should be said to workers. In the same vein, proper training for health and safety and joint health and safety committee members is key. Ensuring that your organization is attuned to the reporting requirements is vital. Training for decision makers on whether to report or not is important, and ensuring that the internal regular audits of the safety reporting mechanisms happen. The internal responsibility, or the IRS system, is the foundational legal philosophy of occupational health and safety across Canada. It mandates that everyone in a workplace, from senior executives to entry-level workers, share the responsibility for maintaining a safe and healthy environment. Rather than relying solely on outsider inspectors to enforce rules, the Ministry of Labour, the IRS empowers the workplace's internal team to identify and resolve hazards. Responsibility is distributed based on every person's relevant level of authority and control. Workers, most importantly, must be aware of their three rights: the right to know, the right to participate, and most importantly, the right to refuse unsafe work. Internal investigations are also important, that internal health and safety teams conduct an investigation and understand what went wrong. Although daunting, ensuring that this is a formalized requirement of your workplace incident management strategy is vital to help prevent further issues from arising. An internal organization should be investigation, should be conducted with the injured worker, supervisors, and more senior members of the organization. It gives it should focus on the incidents, but more importantly, improvements that can be made. This only not gives confidence to your workforce to that the company places strategic importance on safety, but is also a requirement of the Act. Following the incident, the Ministry of Labour will spend a significant amount of time investigating. Typically, charges are laid within 2 years of the incident happening. Since then, many improvements that are related to the incident should have rightfully been made, with processes and new policies created. Although this won't change the charge itself, it is a good practice to ensure that all these improvements are recorded. This may be important to do when we're looking to mitigate any potential penalties that the company may face. Many companies have made these improvements, but then they fail to record them, leading to an improper and unjust way of legal counsel being able to defend these and say that the safety strategy has improved. It is important to have this recorded, as the stronger defense that we could have could potentially mitigate or lower any issues or fines that are raised. The Ministry of Labour, at times rightfully, holds the employer to a very, very high bar to ensure worker safety. Giving them any reason to add on a charge, for example, the delayed reporting of the Section 51 report, should be mitigated. As a reminder, corporations can be fined up to $2 million per count. Directors and officers can be individually fined up to $1.5 million with potential imprisonment for up to 12 months. Individuals and supervisors can be fined up to $500,000 per count with potential imprisonment for up to 12 months. Now, these are significant numbers that can be easily mitigated. Managing the workplace and managing the expectations of the workplace is also crucial. Ensuring that proper communication channels exist is key. For example, can workers easily access a copy of the health and safety manual for any questions they have? Can employees easily access the minutes of the last Joint Health and Safety Committee meeting? Both of these are requirements under the Occupational Health and Safety Act, and many employers fall foul of it. Both of these things can be easily satisfied by making them available in an online, secure server which employees can access from terminals at the worksite rather than constantly printing them out. Having access to safety-related information is very prudent for employers to provide their employees. Not only is it a requirement under the law, it also allows employers to foster a culture of safety from the get-go. Employers who recognize and place strategic importance on safety results in lower costs and, more importantly, allows their workers to go home safely every day. With that, I'll pass on to Claire, who will talk about workplace harassment and violence.
Thank you very much, Anil, and good afternoon again, everyone on the East Coast, and good morning to those of you on the West. Staying in line on the occupational health and safety topic, Anil has provided you with a kind of wonderful introduction to some of the things that we deal with in that space. And we thought that we'd touch on another topic that often comes up in workplaces, and that relates to workplace violence and workplace harassment allegations. And so for the next about 10 minutes or so, I'm going to take you through a bit of a refresher about what we're talking about when we use those terms, what trends we're seeing in the law in terms of how enforcement is being imposed, and what some takeaways are for you in that regard. So kicking things right off, I thought I would start with a bit of an update, and that's as of September 1st of last year, every province across the country has implemented a requirement under their respective provincial occupational health and safety legislation that requires employers to implement a workplace harassment prevention policy. So up until this point, most provinces had some sort of requirement of this nature, but now all 10 provinces have a requirement of this nature in place. Generally, the obligation applies regardless of the size of the workforce, so that's important to keep in mind. And most of the pieces of legislation, the Occupational Health and Safety Acts in those provinces, have some sort of requirements with respect to what needs to be in the policy, how the policy is to be implemented in the workplace, and where it's to be posted, as well as what to do when an employer receives an allegation of workplace harassment. And so for the next portion of this morning, I'm going to take you through kind of what these terms mean. So kicking off to the definition of workplace violence, under the Ontario Occupational Health and Safety Act, Workplace violence means the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker, an attempt to exercise physical force against a worker in a workplace that could cause physical injury to the worker, and a statement or behavior that it is reasonable for a worker to interpret as a threat to exercise physical force against the worker in a workplace that could result in physical injury to the worker. And so the takeaway from my perspective with respect to this definition is that one, it relates to a person, not a worker. So when we're talking about who the person is who's either exercising that physical force or making those types of threats, it could be anyone. So it could be anyone in the workplace. So customers, if it's a public facing workplace, it could be clients, it could be suppliers, you name it. And so it's important to keep in mind that it doesn't have to be a worker who is engaging in that physical act or the threat of that act, but any person that's in the workplace. And so turning to the next slide, we'll talk about the definition of workplace harassment. So, workplace harassment under the Occupational Health and Safety Act is defined a bit more broadly than the definition of workplace violence, and it includes engaging in a course of vexatious comment or conduct against a worker in a workplace, including virtually through the use of information and communication technology that is known or ought reasonably to have been known to be unwelcome, or workplace sexual harassment, which is defined separately. And so the takeaway from my perspective when it comes to this definition is that the phrase vexatious conduct or comment is defined very broadly. And so it's often interpreted as including conduct that one could consider annoying, frustrating, irritating, or bothersome. And so it's really important that employers understand that this is a broad scope of conduct that could fall into this bucket. So we really need to make sure that we have mechanisms in place where when these types of allegations arise or there's concerns with respect to this type of conduct in the workplace, there's a clear mechanism that's in place to flag this for the employer's attention to allow you to take steps like investigating, as many of the local or the provincial occupational health and safety laws require you to investigate allegations of workplace harassment. The other piece I wanted to flag is that under the Provincial Occupational Health and Safety Acts, there's protections for workers that raise these types of allegations against any sort of reprisal or negative treatment as a result of raising that allegation. And so this isn't an exercise about deciding whether or not you agree with the allegation, but it's about understanding that when you receive these allegations, certain obligations are imposed on you and are triggered that you have to action promptly or risk being found to have breached the Occupational Health and Safety Act. Turning to the definition of workplace sexual harassment under the Occupational Health and Safety Act means engaging in a course of vexatious comment or conduct against a worker in a workplace, again, including this virtual workplace, because of sex, sexual orientation, gender identity, or gender expression, where that course of comment or conduct is known or ought reasonably to have known to be unwelcome, or making a sexual solicitation or advance, where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. So again, a bit of a mouthful of a definition, but the real takeaway is that it's not for the employer out of the gate, shall we say, to decide whether or not there's merit to the complaint. It's about understanding that if you receive a complaint that falls within this bailiwick, or you become aware of a situation that took place in the workplace that falls within this bucket, that you're ensuring that you promptly comply with your obligations that are triggered as a result of receiving that complaint. So now we're going to talk a little bit about enforcement. And the reason all of these things matter is, from my perspective at least, and I'm sure from a business perspective as well, is that there are consequences if you're found not to comply with these particular obligations under the Occupational Health and Safety Act. In particular, Ministry of Labor inspectors, or whomever is responsible for enforcement of the Act in your particular province, have broad powers generally to enforce compliance with the Provincial Occupational Health and Safety Act. And so their powers include being able to issue compliance orders, which is essentially a document that requires you to take certain steps so that in the inspector's eyes, you have now come into compliance with the act to demonstrate your compliance. But they also have powers to lay charges against employers for breaching the Occupational Health and Safety Act. And since there are these provisions in the Act that deal with workplace violence and harassment, we're increasingly seeing a trend in circumstances where an employer is repeatedly failing to comply with these obligations, the ministry actually taking the action of laying charges against those entities. And in circumstances where an employer is found to have been convicted of the offense of breaching the workplace violence and workplace harassment provisions of the Occupational Health and Safety Act, we have seen fines imposed in the range of $70,000 to $80,000. And so I think for me, that just the takeaway here is that the ministry is very focused on making sure that employers are taking every reasonable precaution to protect the health and safety of workers in the workplace. And that includes with respect to preventing workplace violence and harassment. And so the takeaway, I think, is to make sure that you've got some sort of clear mechanism in place so you're able to identify when these provisions are triggered and then are able to follow through in your obligations in that regard. And so to wrap up my portion of this afternoon's webinar, just wanted to emphasize that again, it's really important to make sure that you understand what the requirements are under your respective provincial Occupational Health and Safety Act when it comes to workplace violence and harassment. Today, I've really focused on the obligation to investigate, but there are other things that you might have to do. You might have to post your workplace violence or workplace harassment policy somewhere in the workplace that comes to the readily attention of workers. You might have to conduct a workplace violence risk assessment that informs the contents of your workplace violence policy. You might have to implement training for workers across your workforce with respect to the workplace violence and the workplace harassment policies. And you might have to regularly review those policies, such as on an annual basis. And again, failing to do any of those things could lead to the ministry issuing a compliance order that requires you to do that, and or something more severe, shall we say, like charges being laid against the company. So really important to make sure that you understand what those requirements are and how you're going to comply with them. It's also really important where you have that legal obligation to conduct an investigation that you do so promptly. Where there's delays in starting investigations, it can create opportunities for there to be found to be breaches. And so I think it's really important that we make sure that we're acting promptly. We know who is going to be responsible for investigating these types of complaints and how those complaints are going to get to that individual, so there aren't any sort of gaps with respect to remitting that information once you receive it. Anil mentioned this in his presentation, but again, want to emphasize that it's very important to diligently record the steps that you're taking. So making sure the complaint is recorded in writing, of course, also kept secure, but recorded in writing. And then all of the steps in your investigation are also recorded in writing and kept in a confidential manner to, again, demonstrate your compliance with these obligations under the Act. And again, it's important to review your policies regularly, even if you're not in a situation where the occupational safety laws that apply to your workforce require you to do so. Just as a best practice, it's great to make sure that you're regularly reviewing these things so you're familiar with them and the obligations become a lived element of your workforce. And so with that, I will turn the floor over to Barbara to take us through a bit of a pensions and benefits spring cleaning, shall we say. So over to you, Barbara.
Thank you very much, Claire. Good morning, good afternoon, and happy lunch to those joining us from across the country. I'm going to be providing a quick update from a couple of different aspects with respect to pensions and benefits. And if I can have the next slide, please. So just as an agenda, I'm going to start off with an overview of the Financial Services Regulatory Authority of Ontario, or FSRA. So really focusing on plans registered in Ontario, just for the probably about half of what I'm going to be speaking about, just because there have been a couple of updates that I wanted to talk about. Then I'll quickly just touch on the Ontario and federal budget before turning to some updates on retirement and savings plans and one small update from the Canada Revenue Agency. So just to start off, the first thing really that people are working on right now is getting ready to file your annual information returns. And in doing that, FSRA has asked, as part of pension services portal security enhancement, that you complete kind of a data cleanup as you're doing that. They're really looking for plan administrators to look at certain information that might be outdated, such as the plan sponsor, administrator name, the pension plan name, and as well as the contact information. So if you've gone through any, kind of restructuring or transactional or anything with the business, you're not just dotting the I's and the T's on the corporate side, but they are also making sure that all the information with respect to the plans is also correct. FSRA also announced that in June 2026, as part of their security enhancements, that they are introducing the CAPTCHA function in order to prevent unauthorized login attempts. So they're really kind of focusing on making sure that that portal is safe, secure, and up to date. Next, FSRA also provided an update on the retroactive adverse amendments, which is the next slide. Thank you. So just as about a bit of background, in June, FSRA released the pension plan amendments guidance, which focused on providing interpretation and approach from FSRA with respect to certain PVA provisions and the amendments, specifically retroactive adverse amendments or RAAs. FSRA, does not generally register RAAs, and apologize, there's a small typo there. However, FSRA has announced that, FSRA does have the discretion to register an RAA. What they do is they look at the negative retroactive impacts on the rights, and they weigh that with whether or not that is offset by considerations of transparency, the impact, reasonableness, and equity. And one thing that recently has been provided by FSRA are summaries of these. Specifically, what FSRA has done is it's created 2 documents, and we now have 4 releases. So 2 releases where they have listed and summarized anonymized summaries of where they have registered an RAA, and then 2 where they have not registered, and sorry, that should say not registered RAs instead of non-registered. So what that does provide some background. So if you do have a retroactive adverse amendment that you are considering, there is some great information in there providing summaries of where they have, allowed a registration of such an amendment versus where they have not. And in March 2026, FSRA also reminded stakeholders that amendments relating to windups and asset transfers are considered to be adverse, and they must be filed before the effective date, or else that will result in a possible delay of the windup or asset transfer. If we can move to the next slide. The first annual enforcement annual report was released on March 30th, 2026. This report provides an overview of the statistics of investigation and enforcement outcomes that FSRA has been completing. The good news is while FSRA has increased these enforcement actions, there's been 100 during the fiscal year of 2024-2025 that they reported on, compared to 65, only 2 related to the pension sector. So not something that, we should be entirely concerned about, but it is something that we should be mindful of that does, is part of FSRA's mandate, and the reports are available currently online. Sorry, the report, there's only 1 so far. Next slide, please. So one thing that I wanted to also point to is FSRA does do a pretty good job of sending out some reminders. I know that there are newsletters from November, March, and May of 2026 now. I'm only going to focus on the 2 most recent, but what they do is they do summarize areas of where they have noticed ongoing issues. So in the March 2026, for example, as mentioned already, the pension plan amendments related to windups and asset transfers must be filed before the effective date, as well as they mentioned that plans with excess surplus that are considering a contribution holiday, they must still comply with statutory requirements. And this includes a cost certificate within the prescribed timeline to be filed. So there are kind of reminders of their, of issues they've seen across the industry. Also, with respect to incremental cost reporting and actuarial information summaries, FSRA reminds stakeholders that they should be reported as an annual average over the reporting period and not as a cumulative amount or annual incremental cost following the valuation date. So there are those reminders in there. In the most recent newsletter, the reminder was with respect to the annual information returns, which are upcoming and related with how individuals across different jurisdictions are reported. Moving on to the next slide, I'm not going to spend too much time on this just because it could be a topic almost of its own. The supervisory approach guideline to implementation of the target benefit MEP framework became effective as of February. And in the March 2026 newsletter, FSRA announced that it updated the plan wind-up and surplus application website. So if you are considering a wind-up or a surplus application, FSRA has now made it a little easier to navigate the information and streamline the application process through a revised website. And that is also linked in the newsletter that they do provide that is available on their website. So moving on to the Ontario budget, which was released March 26, 2026, we did see a couple of updates from the pension side. One of them being that they increased the Pension Benefits Guarantee Fund guarantee limit from $1,500 a month to $3,000 a month with no increased cost to employers. And that amount increase is effective as of March 26. Also, there is a proposed amendment to the Pension Benefits Act that was announced for the discharge of plan administrators related to unlocatable members. And this is, a topic that I think a lot of pension plan administrators do have a lot of, trouble with. So what will happen is plan administrators would be required to conduct additional searches for unlocatable members and, subject to a prescribed waiting period, will be discharged for the liability relating to those plan members. Also, we saw proposals, the budget proposed to offer a new unlocked option for funds that have been transferred from a pension plan to a locked-in account, and draft regulations will be released to allow variable life benefits to be included in pension plans with DC benefits or additional voluntary contributions. There's also going to be a consultation on regulations to terminate PBGF premiums for plans transferring to JSPPs at some point. At the point when the plan beneficiaries have consented to the merger, which is much earlier than currently, which is when I believe the regulator approves it, so FSRA approval. So we'll see that. And then I'm going to skip through the next two kind of topics just to make sure that we're on time and move on to the federal budget. This impact has some recent updates. So we did see in the federal budget of 2025 that there were changes to qualified investment rules for certain plans, the RSPs, RIFs, TFSAs, FHSAs, RDSPs, and RESPs. And as of May 6, 2026, the federal government introduced Bill C-31, which included the proposed amendments that would add two new categories of qualified investments and repeal the registered investment regime. I did check as to the status of that, and that has not yet passed. So we should see that pass pretty quickly. But as of yesterday, it had not yet passed. Moving into retirement and savings plans, I'm sure you've all heard about CAPSA, which is the Canadian Association of Pension Supervisory Authorities, quite a lot. If you have not, that is okay. But if you do have a registered and savings plan, I think this is an area where we can see some improvement. So RSPs, TFSAs, DPSPs, not just the actual registered pension plans. There was the revised CAPSA guideline that was released in September of 2024. It is now effective. It was effective as of January 1st, 2026. We did see the CAPSA guideline number 3, which deals with capital accumulation plans, be revised. There was a change to the standard of care and governance requirements, specifically with respect to capital accumulation plans like RSPs, GSPSPs, and all those other savings plans. And what we did see is, the increased need for a written document, which would govern the governance framework. And a few other sections were updated, including member communications, investments, financial planning, and service providers, all very important areas to focus on. So if you have not had a chance to revise or implement any kind of governance structure for your plans, whether or not it is a registered pension plan like a DB or DC pension plan or a capital accumulation plans, this is definitely the time to be doing that. We do have some guidance that we can provide in a model governance framework that we can assist with implementing, just to make sure that you are providing the appropriate standard of care and governance framework for those plans. I also do want to mention, and I'm not going to spend any time on it, but for registered pension plans, we also did see the new CAPSA guideline number 10, which is equally important. I'm not spending time on it on this webinar just because this is kind of meant to be a spring cleaning, what have we caught up on? So we have done a couple of sessions on these already. But if you do have any questions and need any assistance, we're more than happy to assist you with implementing the CAPSA changes. Again, CAPSA is not law. It is quasi-regulatory, though. It is a best practices because it is made up of CAPSA is made up of the regulators across the country, including the CRA, and they, them coming together and providing best practices of what they expect. And then on to my final slide, just I think a good piece of news. The Canada Revenue Agency has reached the modern era and has announced that they are modernizing the My Registered Plan account. It is to launch in the spring of 2026. I have not seen any updates as to when that will exactly happen, but I did check and it didn't appear to have been announced yet. So the Registered Plans Directorate of the CRA will go from a paper-based process to a digital solutions basis, and providing access to various services, including filing various documents, electronic communication, document submission, and it will be accessible to plan sponsors, administrators, and trustees of registered plans. That is all from me. I am sorry I spoke very quickly. There were quite a bit of little updates I needed to provide from all over the spectrum. But if you do have any questions on, pensions or retirement or savings plans, we're more than happy to assist.
Thank you, Barbara. And thank you to all of our speakers for sharing their valuable insights. If you have questions, now is the time. Please feel free to pop them into the Q&A. I do see a few questions. There's a number of them on our on foreign workers, and in fact, a series of them. Unfortunately, John had to go to another meeting, but we will try and follow up on this because there's obviously a fair amount of interest on this issue. In the interim, however, perhaps Anil, maybe I could ask you. There was a question in the chat about an organization that has a joint health and safety committee, but where the employees don't go into the office. Everybody works remotely. The question, does the committee have to complete or just have to complete their quarterly meetings, or what are there special requirements where you have people who are just working remotely?
Yeah, so thanks for the question, first of all. Long story short, the answer is yes. They do have to complete the meetings. And I would recommend in a kind of remote environment, what makes the most sense is the minutes now are very easily disseminable. You can have the virtual meetings, have the virtual Joint Health and Safety Committee quarterly meetings, and then, that those notes could be sent out in an email or whatever online server the organization uses and say, hey, we just had our meeting, here what it is. Now, obviously, it's a bit more difficult with the Joint Health and Safety Committee conducting, workplace inspections, things like that. That doesn't really need to happen per se. But what I would recommend is a self-inspection process, which is basically getting employees to kind of almost self-record any potential issues that they might be having, any trips that they might have experienced working from home, or any potential, mental health issues that might be present. That's all I'd recommend, just self-reporting, creating that mechanism for them to report since everyone's remote.
Thank you, and thank you. I've really appreciated your practical tips here today. I think we're actually pretty much out of time here, so I think what we will do is just give you back a moment or two of your time,